Hello everyone, good morning. I'm now at Lead Law Library at University of Leeds, and today we'll be covering on the area of arbitration. So in the previous lesson we learned about tribunal as well as mediation. So what's the difference between those two and arbitration? So let's start with the definition of arbitration itself. If you look at the Blackstone's commentary, it talks about an agreement or a bond between two or more parties to decide on a matter by an arbitrator. But the differences between arbitration and tribunal or mediation is that it involves commercial dispute. So if you look at the definition provided by the Oxford English Dictionary, arbitrator itself is a person and must be neutral who can assist the conflicting parties to come up to a decision. An arbitrator is able to decide according to the one's will, pleasure, uncontrolled, and is an absolute decision. So when we talk about absolute decision, it's not simply because he or she decided uh, accordingly, but it depends on the facts and the circumstances of the case, of course. So when it comes to arbitration, it's something similar like tribunal because the arbitrators are bound by the Arbitration Act as compared to tribunals because there are so many lists of tribunals. Tribunals are established according to the legislation. Whereas mediation, there is no need for a legislation to be established or set up which governs mediation. So these are the differences between arbitration, tribunal, as well as mediation. So this is an example I mentioned earlier when we talk about legislation. There is an Arbitration Act 1996 in the United Kingdom, which governs all arbitration in England, Wales, and Northern Ireland. So the Arbitration Act itself is heavily influenced by the United Nations Commission on International Trade Law Model Law. So as you can see, the provision is based on UNCITRAL, and other countries which adopt UNCITRAL model will have similar provision as in England. So this is another number one important difference between arbitration, tribunals, and mediation. Because for tribunals, I gave an example, employer and employee. If employer is not happy with regards to being fired or dismissed by the employer, the parties can take an action, bring the matter to the tribunal for the matter to be deliberated. Whereas mediation, I gave an example with regards to family dispute, husbands and wife who wants to separate, so they can mediate in order to come to an amicable solution. Whereas for arbitration, in order for parties to go for arbitration itself, Section 5 of the Arbitration Act mentioned there needs to be an agreement in writing, a contract, and there must be a provisional section which mention if there's any dispute between the parties, then the parties will need to opt for arbitration. So you need a specific provision or clause in the agreement. So agreement and legislation are two separate things. First, you need a legislation arbitration act which govern arbitration in England. And secondly, you need an agreement between, let's say, Mr. Adam and Mrs. Smith, for example, and Mr. Adam and Mrs. Smith sign a contract, and under Section 10, specify if there is any dispute, parties will opt for arbitration. Whereas in tribunal, there is no need for an agreement, or there is an agreement, a tribunal is not mentioned there. Whereas mediation, when parties get married, in their marriage contract or marriage agreement, there's nothing mentioned parties need to opt for mediation. So this is an example of a commercial agreement between two parties. This the one that I've adopted when I was in practice in a law firm. So you can see this agreement is made on this day, and then you have a definition section, and then at section 4, there's mentioned dispute resolution. So if there's any disagreement between parties, before parties can go to court, parties need to go for arbitration first. Or, for example, if there's any dispute, the only way to resolve the dispute is via arbitration without the need to go into court. So then the list of dispute resolution in terms of the venue, choices of arbitrators, all will be specified in the agreement. So the scope of arbitration as I mentioned, because it involves a lot of commercial dispute, so a wide range of contractual and non-contractual claims can be referred to arbitration. And the examples includes the one that listed on the slide. So any matters relating to competition law, IP, insurance, construction, shipping, all can be referred to arbitration. But with regards to family matters or criminal matters, it cannot be referred to arbitration. So these are the general principles of arbitration itself. When we talk about arbitration, because there needs to be an agreement which specify the choices of arbitration, uh, it means that arbitration is consensual between the two parties. Two parties need to agree to it because the two parties need to sign the agreement. So the parties have the option to choose the arbitrators. Usually the arbitrators would be three arbitrators sitting as a panel members. So party A can choose one arbitrator, parties B can choose one arbitrator, and then the third arbitrator can be a neutral person assigned by the arbitration committee. The arbitrators are very skillful and knowledge and experience because they are highly specialized individuals in areas of insurance, shipping, or IP. Arbitrator itself needs to be neutral third person so that there's no biasness with regard in either party. So whatever happens in the arbitration proceedings considered as confidential, so which means other parties who are not in the arbitration proceeding will not know anything that happened or transpired during the discussion, and whatever decided by the arbitrator, it will be listed it out and it becomes binding. But the problems with the confidential proceeding is that there's no doctrine of binding precedent, which means if there's any similar matters with regards to shipping, so means that the existing parties do not know what was decided by the arbitrators in another similar case relating to shipping. And the decision of the arbitrators is final and is enforceable in court. So I've done some homework for all of you with regards to the differences between tribunals, mediation, and arbitration. So as you can see, tribunals are creation of statutes. So it depends on the area that the parties are claiming for relief, whereas mediation, there's no need for a statute. So parties are highly encouraged by judges to opt for mediation before going for litigation, whereas arbitration, parties need to have an agreement. Agreement should specify that parties agree to arbitrate the matter and it must be included in the arbitration clause. For example, this now section 4. So it's very important for all of you to understand the differences between tribunals, mediation, and arbitration because this is a common question that will come up in the examination. And parties usually get confused when it comes to application of tribunals, mediation, or arbitration in a problem question. So, for example, a past year examination question I've extracted. As you can see, the question will ask, okay, these are the parties. These parties have this problem. So, which alternative dispute resolution should the party opt for? For example, number one, if you have husband and wife, so which alternative dispute resolution that the party need to opt? Is it tribunal? Is that correct? The husband and wife, do they need a legislation governing uh, alternative dispute resolution with regards to marriage or family dispute? Or is it arbitration? Because arbitration deals with commercial matters. So, of course, when it involves husband and wife, the answer would be mediation. Then you talk about the processes of mediation, the employment of mediation, advantages of husband and wife opting for mediation. And for number two, you have a situation where someone who is pregnant and the employer dismiss her. So what is the relief that she's entitled for? So how can she do it? Does she need to go to arbitration? Like, does it involve employment dispute? So of course not arbitration because in the contract it won't specify if there's any dispute parties will go for arbitration. So will it be mediation? Maybe, or would it be tribunal? So if you look back at the previous videos, then you understand in this type of situation, tribunal would be the best method for Shanas to take an action against the employer. So as for part B, because the question asks for students to discuss the reasons why ADR have increased in popularity. So students who achieve the grade of B tends to just explain the advantages and disadvantages of mediation, but students who achieve grade of A will include cases as well as discuss with regards to the application of ADR back in those days and currently, because the question mentions popularity, so you need to highlight on the development of the application of ADR. So with regards to another example of past examination question, so sometimes exam question do provide a code, and students will need to answer this question part A and part B and must highlight on the code given as well. So even though it's fairly straightforward when the question asks about advantages and disadvantages, students tend to directly answer the question without relating back to the code. So that's the distinction between A student and B student.